Good afternoon, everyone. So, this is the part 3 of your module 3. Nagka-problem lang with the recording, but I continued na. So, if you have your modules with you, you can scan through it and makita nyo nga ara na kita sa characteristics of consent. So, in order that consent may be valid for purposes of contract, it is required not only that it exists, but that it must be given with exact understanding of the thing consented to. So, hindi lang nagamatter nga, yes, may aras ang consent. Nagamatter man nga naintindihan sa contracting parties ang iya nga ging agrihan and um ang consent naging hatag niya, it was free and voluntary act. And it was also spontaneous, kag may consciousness siya at the time of the giving of the consent. Say for example, bala a person nga hubog or drunk, he cannot give an intelligent consent. Kay man, ang consciousness niya at the time of the giving of consent blinded by alcohol. And also, a person naging pilit or, for example, sa kilid mo may ara nga ginataya sa imo nga pusil, tapos ginapahuo ka, and if nag-say yes ka dito, nag-give ka sang consent mo, while ginatutukan ka sang pusil, that's the time nga hindi mo masiling nga ang consent ginhatag freely and voluntarily. So even though may consent nga ginhatag, it cannot create a valid contract because ang consent ginhatag was not given freely or voluntarily. Bali vitiated ang consent. May defect sa consent. So, what are the vices of consent? So, na-discuss sa previous nga recording nga ang may once a person is incapacitated to give consent, say for example ang minority niya, ang iyang if he is deaf, mute, and unable to read and write na, may vice ang consent or may defect ang consent. But there are other reasons also nga makonsider man naton nga there is a defect sa consent. And this ang the defect in the consent while making a contract can create a voidable contract. Ang to gani hambalta, voidable contract means valid until annulled. So what are some of vices of consent? So number one, may error or mistake. Nagsala ka, wala ka, lain gali ang ging agrihan mo, abi mo amo na to, abi mo on the same page ka mo, gali lain. So may error or mistake that can create a voidable contract. Next, there is violence or force at the time of the making of consent. Amo to siling takagina. For example, bigyan na sinumbag ka na, ginabugbog ka na to, samtang nga ginapahuo ka. Tinaghuo ka na lang ikit, sakit-sakit na puno ka na sang pilas, kag nasa putihan ka na. Nag-yes ka na lang. That yes mo, even if it constitutes a consent, it is considered a vitiated consent and it can create a voidable contract. And another is intimidation or threat. Amo to hagi example kung ginatayaan ka sang pusil, that is intimidation. Intimidated ka hadlukan ka. Syempre, kung hindi ka mag-yes, bas ipalupok ito ang pusil sa imo. So amo na siya. Another is undue influence. This happens when a person bala nga nagapilit sa imo nga mag-agree ka sa isa ka contract is someone nga senior sa imo or mas superior sa imo. Say for example, bala ginpili ara ka sa custody sang police, ginapilit ka ba lang mag-testify even though wala mo to nakita pero gusto nilang maghambal ka nga huo para sa record. Meaning ang consent pag maghambal ka nga okay naghuo ka to abe nag-give ka sang consent mo dito sa statement nga to kita sige sulat na bisang police, then meaning you have given your consent because of undue influence because nahadlo ka sa iya kay man gingamit niya ang pagkapulis niya para makuha ang consent mo. That is only an example. The same is true for example kung mga barangay captain, mayors, or ang mga boss mo big, if you are in a business setup, ang mga managers mo, ang ginpilit ka nga engage sa sexual activity, gingamit niya ang pagka-manager niya or pagka-supervisor niya, o hindi ka magsugot, i-fire ta ka. Meaning, gingamit niya is ang undue influence niya, ang iyang influence as a manager para makuha niya ang consent mo. Another is fraud or deceit. Ging tunto ka. Diriya, wala ka gid idea, ging kuha niya ang consent mo kay tinatuntuhan ka. Baliging into niya ka nga, uy, wala ni siya, wala ni problem ang duta. Sige na bala, enter ka na sa contract sa akon, bakla na lang ni ang land. Wala ni siya sa vlog, ang kompleto ni tanan-tanan nga papilis. So, nag-enter ka into a contract. But then, igo galiyab sa katapusan na, may mga third party nga naghambal nga, hindi ari na di sa akon, prendado na sa akon ang lupa, so hindi mo na pwede mabakal. So, dira, nag-enter ka into a contract because you were deceived or naging tunto ka. So, that creates a voidable contract. Okay? I hope it is clear sa inyo. I've given examples and iligay no nagidin. So, what's the effect of knowledge of risk? For example, bala ma-enter ka sa contract nga may involvement of risk. Most of the contracts involve risks, pero depende kung ano nga klase ka risko. If a party knew beforehand the doubt, contingency, or risk affecting the object of the contract, it is to be assumed that he was willing to take chances and cannot therefore claim mistake. Say for example, nagbalaan mo nga dako ang risgo sina. Nagbakal ka sang duta nga wala ka gipakitaan sang titulo. Pero gasiling lang siya nga, may titulo ni at ito sa bata niya, kwaong ko pa. Pero napilahan lang, wala gid sang gipakita nga titulo. So, at that point pa lang nga daan, gina-expectar mo na nga duwa-duwa kung may titulo. So, it is up to you if masulod ka sa contract, mahatag ka sa consent. And if by chance nga nag-agree ikaw, then hindi ka naka-claim nga may mistake. Nga hala, wala galisang wala galisang titulo. Sa latong akon nga pag-agree kay abi ko may ara. So, no, you cannot claim that already. Kumbaga, stop na ikaw to question that kay man from the time nga nag-enter ka mo sa contract, sa negotiation pa lang, dugay may doubt na as to the existence of the title. So, amo na. Another is nag-discuss kita sang fraud. So, ang fraud diri nga ginanami naton is causal fraud. So, the causal fraud nga ginanami naton, which vitiates consent, is a fraud committed by one party before or at the time of the celebration of the contract to secure the consent of the other. Nagsiling ka causal fraud, ang fraud nga na or ang pagtunto nga na ginhimo bag-o mag-enter sa contract or during nga ginahimo ang contract. So, amo to ka ginang example ta. Gimbaligya na nakaprenda na naayagali ang land. But then, ginghambalya, gimpasaligya ka nga, no, ang ako ni ang rightful owner, wala ni problema, wala ni sablag ang duta, pwede mo na ni mabakal. Tapos gimbakal mo. Only to find out nga pagbakal mo, may third party nga nag-claim nga, no, hindi mo na pwede mabakal. It's because prendado na sa akon, ari na sa akon subong. So, in that case, there is causal fraud. Pwede mo masiling nga may fraud. And that causal fraud constitutes a vitiated consent which creates a voidable contract kung nag-enter ka into it. So, causal fraud may be committed through insidious words or machinations or by concealment. Amo to ging tago-tago yang aprendado gali. Kaging dalaya lang ka sa smooth words nga okay, ang wala ni problema. But there also a fraud naman. Amo na i-discuss ta kung ano ang fraud by concealment, ang ging tago-tago niya. Ang fraud by concealment, amo ni siya ang neglect or failure to communicate or disclose that which party to a contract knows and ought to communicate constitutes concealment. Ang magambag ka concealment or ging tago bala, amo na isa man na siya ka pangtunto nga paagi if dapat ging sugid mo but wala mo ging sugid. The same is true sa example ko. Dapat if prendado ang item nga imo nga ibaligya or di gani wala pa sa ang it is not yet in your possession, dapat ihambal mo na because ang object nga is the subject matter amo na ang rason nga ma-enter siya into a contract. So dapat ihambal mo sa iyang status sina. Otherwise, you will be guilty of fraud if may mga problems along the way because of that information nga gin-conceal nimo. So ano naman niya ang simulation of contracts? Kay aside balaan sa vitiated consent, ang simulation of contract, it can also create a voidable contract, valid until annulled. So ang simulation of contract, it is the act of deliberately deceiving others by feigning or pretending by agreement the appearance of a contract which is either non-existent or concealed. So, bali, meaning sa simulation of contract, um, nag, naga, it's a, pariyo man eh, this is also a fraud. This is also deceiving a person. You are intentionally deceiving others. So, naga-pretend ka, or gapakuno-kuno ka lang dire nga may contract, even though wala gali isang contract. So, may duwan ang kaklase ng simulation of contract, ang absolute and the relative. So, sa absolute, when the contract does not really exist and the parties do not intend to be bound at all. So, wala gid isang contract, pero gintunto mo siya nga, uy, di ba, you owe something from me? Diba na? So, in reality, wala gid siya isang contract. So, if there is absolute simulation, hindi lang ni siya voidable ha. It would result to void or inexistent contract gid mismo. So, ang simulation of contract that would create a voidable contract, amo ni siya ang relative simulation. So, when the contract entered into by the parties is different from their true agreement, the parties are bound by their real agreement provided that it does not prejudice a third person and is not intended for a purpose contrary to law, morals, good customs, public order, or public policy. For example, nag-enter ka mo into a contract of mortgage. So, ging mortgage mo or giprinda mo anay siyang duta mo. Pero ang tutuod ang tutuod ya ang inyo nga ginhimo nga contract ya is deed of sale. So bali ging-hide nyo ang contract of mortgage which is your original or intended contract taning adua. Amo ginataning inyo yung intention ano lang kamo ma mortgage. Ging pagwa nyo nga ging pagwa nyo inaya in the form of deed of sale. So here may duwa ka acts involved. May deed of sale amo na ang ging execute nyo nga form. Tapos ang inyo nga real intention nga contract of mortgage lang tani. So may duwa, di bala? So ang apparent or ang visible ya nga contract nga pwede mo mapakita sa iban is the contract of sale. Pero ang gingtago-tago nyo, kag ang inyong real intention was the contract of mortgage. So, as far as the parties are concerned, the contract entered into between them is contract of mortgage. Pero, as to third persons, kung ano ang apparent contract, amo na iya ang controlling. So, dapat, if you would want to enter into a contract na amo sini, if there dapat hindi siya mag-prejudice sa third person. Otherwise, it can be considered a simulation of contracts and it is voidable. Pwede na siya ipa-annul sa third person nga na-prejudice sang contract nga ginhimo ninyo. Because once nga na-prejudice tong third person, ang material na dira, ang basihan na dira is ang apparent contract and not the intended contract sang parties. Kay man may aggrieved parties sa amo sina nga part. It is voidable and it is considered a relative simulation. I hope it is clear. Mm, so what are the concept of objects of contracts? So hambal ta kagina, hambal ta sa previous discussion ta, um, on the contract, one of the requisites of a contract is ang object. So object of contracts, it is the subject matter. Amo nang rason nga nag-enter ka mo into a contract. So, ang object, it must be within the commerce of men. So, dapat hindi pa siya na-phase out. So, tapos it can be legally be the subject to commercial transaction. So, meaning hindi siya illegal object such as mga drugs, mga illegal firearms. So, those nga pwede mabaligya sa market. Those nga pwede mabaligya commercially. This can be subject of this can be an object of a contract. Tapos, it must not be impossible. It both legally and physically. So, hindi ka makasili nga ang mga physically impossible balang objects, mga hindi man realistically nga ma-produce or mahatag na, hindi na siya pwede maging object of contract. And it must be in existence or capable of coming into existence. Say for example, um, ang mga manug-launch ng mga salakyan na it is capable of coming into existence even though at the time nga ma-enter ka mo sa contract wala pa nag-exist kay wala pa na launch. So pwede na siya maging object of contract kay it is capable of coming into existence. Tapos it must be determinate or determinable without the need of new contracts between parties. Ang nanamin niya di nga determinate or determinable, dapat ang klaro ini kung ano nga klase ka object. Klaro kung ano na ding object ng contract. Hindi nga you would need another contract para maintindihan kung ano gid man nga object ang imo nga ginanamin sa contract nyo nga ini. Okay? Amo ni siya ang requisites if the object of a contract is a thing. Amo na siyang thing nga mga to be delivered. But what if the object of the contract is a service to be performed or not to be performed? So, again, it must be within the commerce of men. Ang pwede ba lang ang legal nga maobra? So, it must not be impossible physically or legally. So, ang pwede man maobra physically. Hindi man na sila nga dapat ang utdun mo lawas mo like the magicians or sa mga sa mga magic tricks. So, I think it's physically impossible man to make that as an object of a contract. So, another, it must be determinate or capable of being determinate. The same is true with this one. Dapat, klaro siya kung ano nga service. You do not need another contract para i-define kung ano nga klase ka service ang inyo ginanamin or ginaagrihan dire. So, amo na siya. Amo na ang concepts ng objects of a contract. So, quantity of object of contract need not be determinate. So, ang quantity na kung kisa, depende man depende sa nature ng contract. Pwede man siya nga hindi siya determinable ang quantity kung pilagi kabilog. But if it is a point of consideration, say for example, dira ang basis kung pila ang price nga inubaydan mo, I think it is, I believe it is material to state the quantity of the object nga imo inug-deliver or ang objects ng contract ninyo. Last essential requisite is the cause of contract. Cause of contract, it is the essential reason or purpose which the contracting parties have in view at the time of entering into contracts. It is something bargained for or given by a party in exchange for a legally enforceable promise of another. So, ano ni siya? Ano ni ang cause of contract? So, amuning purpose. Ang purpose, nga nag-enter man kamo into a contract. Kagina, ang object, amo ni siya mga inug-deliver mo. This is also a purpose of a contract, ang object man. So, amo ni siya yung physical, amo ni makita mo ba nga inughatag mo or mabaton mo if you are a creditor. But the cost of contract, amo naman ni siya ang imo exchange for a legally enforceable promise. Do kumbaga do amo ning inugbayad mo. Say for example, if the object of the contract is a car, delivery of a car, ang cost of contract is the price of the car. Amo na. Kay man, because you would need it. you would need that for business venture or personal use na. So absence or want of cause means there is a total lack of any valid consideration of a contract. So contracts without cause confer no right and produce no legal effect whatever. So illegality of cause implies that there is a cause but the same is unlawful. So kung may cause man pero illegal siya, ang result is null and void contract. Not voidable but void contract. So if there is a false cause, pwede mo siya masilinga erroneous siya or simulated ang contract. And if it is simulated contract, again, if it is relative simulation, it would result to voidable contract alone. But if absolute simulation nga non-existent gid ang contract, it is null and void. So example na ni siya, D promised to give C 1,000 as payment for past services allegedly rendered by C, which in truth and in fact have not been rendered. So, ang cause diri is erroneous and based on facts believed to be existing but really inexistent. So, in this case, there is absence or want of cause. Wala gid ya sang cause. Wala to yan natabo ang services nga to nga gin-promise. So, wala siya sang dapat nga inugahatag nga 1,000 pesos. So, if may absence or want of cause, null and void hindi ang contract. If falsity of cause lang, sala lang ang cause nga na state, and it results to relative simulation, voidable siya. So, I hope we've discussed it well nga maintindihan ninyo. This is your module 3 and this is the last module before kita mag-midterm. So expect to have your midterm anytime soon. I will upload the link of the Google form in which diin ka mo maka-answer sa midterm ninyo. The same the same process. 3 days siya and you would have 3 days to answer it bago mag-close ang Google form. So after that, schedule na or deadline na sang aton nga pasahay sang mga um, assessments and enrichment activities. So I hope that's clear, and if you have questions, feel free to ask me sa akon nga Facebook page, sa Facebook account and sa group chat. So bye-bye everyone.